enough for each and every one of you?
You're
Yes,
audible,
you are.
doctor.
Yes, you are audible, doctor.
Thank you. It's a very beautiful evening. I thought I would have been in Arusha. Unfortunately, I was tied up with work in Moshi, and that is so. Thank you, guys. Once again, good evening, and I see the number is 164, 65 now. I believe others will join us as time goes by. But importantly, is we are progressing today to winding up of a company as a last topic when we are teaching corporate law. And if I'm done with teaching of this last topic, I believe Dr. JJ will have to come for governance, corporate governance in particular. So we have, if we recall, if we go back to, sorry, If we go back to our module guideline, I'm just interested. It's very important that I remind you what exactly is expected of us in terms of what we are supposed to study. I'll stop sharing this one and share the module guideline itself. So we have, if you look at the module guideline, we were expected for this particular course, for this semester, to cover, insofar as corporate law itself is concerned, we were expected to cover 5 topics. Now you see we had introduction to law and contracts. I remind you this many times because I see there's a tendency of most of you forgetting even the module guideline. From the experience, from what I've been able to gather for a very long period of time I've been teaching this course. So we have the first topic, which is basically on introduction to law and introduction to agency and insurance, which associations in the context of what they mean, their nature, how it is different, and the legal statuses for each of them. The objectives being to explain the various forms of doing business, to differentiate company and other business, sole proprietorship, partnership, and cooperatives. And I remember here we looked at 5 business associations. And in introduction to business associations, we were also supposed to look at formation of companies, as you can see here. Companies under company law, there are types, which we did, how are they formed, the registration process, as well as the characteristics they acquire upon formation. We went far looking at, even though a company, incidences where the company will be disregarded as a separate legal person. If the company is a sham, if the company is avoiding tax, if the company is doing something which is against public authority, etc., etc. The third topic was one on managing a company. And we were supposed to look at the management of a company generally, the company meetings, role and duties of the company directors, and the protection of shareholders, particularly the minority shareholders. So we looked at the company meetings, the AGM, the ODM, ordinary general meeting, the annual general meeting. We looked at the specific requirement as to quorum, who preside over in terms of the chairperson, the requirements on notice. We looked also on the issues relating to the agenda for this meeting. So we looked at all these items because it's part of the management of companies. And we were sometimes most times referring to the Companies Act. The fourth topic was on corporate disclosure. As you can see it, I think it is here. That is what we did last time. We looked at the disclosure and reporting in a company. What is it that is supposed to be disclosed? To which authorities are we disclosing? I think it is one of the questions that was asked in your test, if I recall correctly. Company registers, company books of accounts, directors' reports, auditors' reports, and companies' returns. We looked at all these as part of topic number 4. Now we are moving towards the last one in terms of corporate law. And here is where we are supposed to look at winding up. And someone is saying, sikusiki au ni mimi tu managers, asisiki sote. I believe now you're hearing us because it seems like everyone is able to hear me. So last we are supposed to have winding up of the company, where we have to look at liquidation, voluntary liquidation, compulsory liquidation, etc. Now, most people, as I will tell you next, we are looking at winding up and dissolution. It's not just winding up, it has to be winding up and dissolution of a company. So we have to look at the issues of corporate insolvency and rescue, and as an attempt to make sure that the company survives. But this is the topic that we're supposed to look last on the aspect of corporate law. Then you will have to look at the aspect of corporate governance, which I believe Dr. Jeje will come therefore to take over. Now, allow me to go back to my to sharing the PowerPoint presentation that I wanted to share with you on company law. I believe I shared this with you. If not, Agnes, you will then remind me to share it with you. But we have winding up of a company, and importantly, we are talking about bringing a company to an end in terms of its life. So we have a company which we say it is an artificial person and which is brought into existence through the legal process, and now it has to come to an end through a legal process. It is not just like you are a company does not come to an end. It does not die as a natural person dies. It has to go through a legal process where you will now be pronounced dead as a company, as an artificial person. So normally what we see is that a company is brought to existence or is born through registration. We call it registration or incorporation. And when it is incorporated, it acquires the features of a natural person, it being an artificial being. It can dispose property, it can own property, it can sign documents, it can sue or get sued. I think in the test, one of the questions, the question that was for filling in the blanks, that question was basically set to on the features of a company. Separate legal personality, perpetual succession, those features of a company. So the question was set to test an understanding on the features that a company acquires when it is born. So it is born through registration or incorporation, where it becomes like an artificial, although it is an artificial person, it becomes like a natural person. Same way as a human being where you can go to court, same way as a human being where you can own property, same way as a human being when you can dispose such properties, where you can own land, etc., etc., etc. You can sign documents, etc., etc., etc. So the company is born through this process of registration. It lives. Now, this is something that the PPT does not tell you. The life of a company is through its operations, through its existence. So you see, it lives, the life is through its operations. It lives, it operates, it continues. It does so many things. It acquires property, it employs people, it does business, it does so many things, production, manufacturing, etc., etc., etc. Or it offers services depending on the type of a company. That is how it lives. That is the life. You will see any company, you look at it, Coca-Cola, you look at Pepsi, you look at any company that you know, the life of it is depending on the products, it depending on the manufacturing, depending on the sales, it depends on so many things. And these companies normally will come to an end through what we call winding up or dissolution. Madam Agnes, I see we have the same problem, like we have 9 minutes, 47 seconds. Madam Agnes, are you here? Please confirm.
Yes, I'm here, Doctor.
It is happening again.
I've already shared with the IT, but he didn't answer.
Okay. Let us assume that it will restart and then we will log in again. We will join this meeting and continue, right? After the 9 minutes.
Yes.
No problem.
Yes.
Yes. No problem. No problem. Let me not trouble you for I think it is beyond your expertise. Now we continue. It is born, it lives, and when it has to come to the end, this institution will not simply be gone. It will have to go through a legal process. That legal process is what we call it winding up. And it is not equivalent to dissolution. So winding up, in simple terms, is the terminating of a company, is the bringing to an end of a company through the procedure that is provided by law. So the life of a company, or the death of a company, sorry, not the life, the death of a company is what we call winding up. But it has to be one that is through the process of the law, the legal process that has to be followed. So we have winding up, terminating or closing the company through the procedure that is provided by law. Now, there are many reasons that will contribute to winding up. But before I go there, I want to stress on a very important thing, because you will see there are two terms that are being used mostly. There is winding up. There is winding up, and we have what we refer to as dissolution. Now, in the lecture notes that are shared with you, the lecture notes on essentials of corporate law.
Sorry, doctor. Your screen is not visible.
Yes, I know that it is. I'm changing a document, but I shared these notes with you anyway, so you will have to make sure you go through them. So we have what we refer to as winding up and dissolution. The distinction is made clear in these notes here. Just a minute. So if you read these notes, you will find at the end, because winding up comes at the end, winding up and dissolution. I think this is on page 95. So you see the authors here saying, and it's very important for you because the distinction is explained here. The terms winding up and dissolution are sometimes erroneously, kimakosa, used to mean the same thing. However, they are quite different in their meanings. So you see, winding up is a process whereby all assets of the company are realized and used to pay off liabilities and members. Dissolution of the company takes place after the entire process of winding up is over. So winding up is simply all the legal procedures where the assets of a company are realized, whether sold, whether assigned, or anything that is done to pay off the liabilities and members, to pay off creditors, to pay all those to whom the company owes. And once that is done, that all is settled in terms of the debts and liabilities, what comes next officially is simply dissolution. It is dissolution which puts an end to the life of the company. But the other process is simply called winding up. Winding up is the entire thing of selling the properties just to set off the liabilities, which is normally done by a liquidator. So dissolution will simply come to put an end to the life of the company. A dissolution order is normally passed by the court, and it's like the death certificate of a company. So there is a distinction between winding up itself and the dissolution, because winding up is simply the entire process until when everything is done in terms of paying liabilities, and now we declare we have no debts whatsoever, or the property have been all realized and there is none that can be used any longer for paying anything. So now we declare the company as died. The act of declaring or the issue of providing that order, that is called dissolution. That is called dissolution. Some people have often even erroneously or commonly confused the terminology, what we call dissolution, with the bankruptcy. While bankruptcy is a legal process by which now a person is declared as insolvent as an individual, and if it is a corporate person, it is declared insolvent, then the dissolution is just the process, the last stage of making sure that the declaration is made that a company is no longer living its life. It has come to an end. So a company may be wound up. To distinguish between solvency and insolvency, or dissolution and bankruptcy, you would see sometimes under voluntary winding up, you'll see the types of winding up. Sometimes people will simply dissolve their company while they are solvent, economically well off. Not all the times that a company will be dissolved or will be wound up just because it is insolvent. No, it is not all the time, as we shall see. So now it was important to distinguish winding up and dissolution, because here is where we were. Now I have to proceed to, I see I have 2 minutes before this thing corrupts, and then we get the other one. So we have the reasons or the causes for winding up. One of the most common reasons that will lead to this process of realizing the assets of a company before it is declared dissolved will be insolvency, the failure to meet financial obligations. A company is not able to meet financial obligations. If you read the Companies Act, the Tanzanian Companies Act, Chapter 212 of the revised laws of 2023, you would see that there is a provision which tells about the amount which a company, if fails to pay on request from a debtor. And I think last I checked, I don't want to say something that I'm not certain of. I'm trying to consult this act. There is an amount that was prescribed then. If a company is not able to pay a request of a certain amount, then it can be declared as a bankrupt one. We have laws, the Companies Act, it is here, and it is chapter 200 and so we have less than 1 minute, guys. Let us wait for it to, if it goes down, then we will have to rejoin using the same link. And I believe it is going to go down now. So I intend to to finish this session in the next 30 minutes. So we were saying there are so many reasons that may lead to the winding up of a company, realization of its assets, its then subsequent distribution to creditors and the members. And we've seen so many companies wound up because of different reasons. One of these reasons for winding up, though we are saying it depends on the type of winding up, it might be voluntary winding up, it might be involuntary winding up, and the reasons will be varying, mostly different. So we started with just one reason of insolvency, and we are saying there is, at a certain point in time, insolvency may contribute to or may lead to winding up of a company. particularly the company's failure to meet the financial obligations. If the company is not able to meet its financial obligations, this can be one of the grounds for winding up a company. If you read section 282 of the New Companies Act, the revised edition 2023, I don't know if I shared with you this particular act, the new one, but it's particularly important to read the provision of section 282 of the Companies Act, where if you look at these particular provisions, it's actually from Part 7 of the Companies Act, where you see there is the modes of winding up, modes by the court or by voluntary winding up, which means compulsory, and we will see those. But my interest, especially on this reason, the ground, section 278, it says, just reading it, circumstances which a company may be wound up. Now, these are reasons where the company may be wound up compulsorily by court. Maybe a company has a special resolution that the company is wound up by court. The company does not commence its business. You read section 282. The company does not commence business within a year from its corporation, or suspends business for the whole year if the number of members has fallen below 2, if the company is unable to pay its debts. So you see, there is a reason here that when a company is unable to pay its debts, it can be also wound up. If the court is of the opinion that it is just and equitable that the company should be wound up. So when you read the Companies Act, section 282, it gives you the circumstances in which the company will be wound up by court. You see here the causes of winding up. Completion of the objective is added or activity of the company. When members agree to change business, they can wind up. This is voluntary. Completion of the objective, it is automatic. If there's petition by creditors, it is likely because of the suspicions, the inability to pay debts, and order from the court where the companies, it does not, it's not able to do business as such. So combinedly, if you're looking at these causes, if I were to structure them perfectly, I would say now, I'm trying now to put them, apart from what we have, if I am to put them in a very good manner or order, I would ask you first to read section 282 of the Companies Act, which is chapter 212 of the revised edition 2023. Yes, 2023. So if you read this act, especially this provision, what you will see, and I want to put it clear around here, okay? Insolvency, completion of the objective, members agree to change business, failure to commence business, failure to commence business within a year. This is just one of the reasons. Postponement of the business for the whole year. This is just one of the reasons. Then we have number of members falling below required minimum And finally, we have in most parts of Tanzania and under the English law. So these are major reasons. You can see about 8 of them as to why companies may be wound up. The reasons for winding up of the companies. Now, importantly, if you look at the means, this is the revised edition of 2023, okay? And I have to control find part 7. Is it part 7 or part 8? Let's check. Yeah, winding up. It's part 8. This is winding up. Now, if you read from the Companies Act itself, what you see here, one on provisions of section 270, you have the modes of winding up. We know that winding up now is the process where properties of a company are now being realized for the sake of making sure everyone is paid and the members are paid before the company is dissolved. So for the reasons that we have mentioned, you will see that the reasons are combining both the voluntary winding up and the compulsory winding up. There are ways where you find a company is either wound up by the court, and mostly which we say it is compulsory, and those which are constituting the voluntary winding up, which is mostly the members themselves deciding that now we have to wind up this particular company. That is section 270. And now when you come to these modes explained, you will see if you start with winding up by the court. Now, this is the first provision, section 278. We said we have in Tanzania courts of law. We said we have primary court, district court. Then we went further up to look at the district court, which is concurrently operating with the court of resident magistrate, then the high court and the court of appeal. Now, the law says the high court is the one which have authority on winding up of companies. You cannot take it to the district or the magistrate's court. You see? And it says the district and the magistrate court shall have original jurisdiction to wind up a single shareholder. We said in Tanzania before 2016, we had only an understanding that a company is an association of persons, but after the loophole that was used, now a person, a single shareholder can own a company. Now you see this provision introduced that district or resident magistrate court, the one which I said have concurrent and original jurisdiction or authority, they're the ones which can handle winding up of a single shareholder, not the other companies. Other companies must go to high court. So that is very important. At least now you know the courts which are responsible for that. So these are the reasons which I was explaining to you, cases in which a company may be wound up by court. You see a company would be wound up by court if we have mentioned all the 8 reasons, and they are here in the PPT. Now, I wanted to explain to you, when you are saying a company is not able to pay its debts, what does it mean? Now, section 283 of the Companies Act explains the reason referred to as inability to pay debts. And it says a company shall be deemed unable to pay its debts for these, under these circumstances. There are 4. The first one is if a creditor, by assignment or otherwise, to whom the company is indebted in a sum of exceeding 50,000. I was telling you about the Elfamsin, or such amount as may be prescribed in the regulation, has saved the company by leaving the registered office a written demand, and within 21 days kampuni haijalipa, you will be deemed as unable to pay debts. Ukiseviwa notice ambayo inaanzia ya kiwango cha shilingi 50,000 haujalipa, then you will be deemed, or you will be deemed as unable to pay debts within 21 days, and that is the first ground kwamba people can go to court. The company is unable to pay debts, let it be wound up. So that is number one. The situation or the circumstance where you find a company is deemed as unable to pay debts. The second situation where the company is deemed as unable to pay debts is if execution or other process issued on a judgment, decree, or order of any court is returned unsatisfied in whole or in part. Yani mahakama imetoa hukumu, a court has ruled that maybe an employee of the company who was maybe terminated is supposed to be paid this amount of money, and the company is unable to do that. Or a company has to take care of something and the company is unable to do that. Then the company will be deemed as unable to pay its debts. Under the same section, section 283, a company will again be deemed to have failed to or to be unable to pay debts if it is proved to the satisfaction of the court that it is simply not able to pay debts as they fall due. Tumewapelekea mwezi wa kwanza ilitakiwa watulipe, wameshindwa kulipa, wakaja kulipa baada ya miezi mitatu. Tumewapelekea mwezi huo, wengine tena walipeleka hivyo hivyo wakalipwa baada ya miezi 6. That cumulatively will then be proved as the inability to pay debt. And number 4, the company will be deemed as unable to pay debts if, to the satisfaction of the court, the value of the company assets is less than the amount of its liabilities. So you see, these here are also, this is the 4th situation where a company will be deemed as unable to pay its debts under the Companies Act. 1, if the company is unable to pay the 50,000 or so within the period of 21 days. 2, if an order is issued by the court and the company is unable to satisfy the whole of it. 3, if the company has accumulated debts and it has a tendency of dodging payment dates. Inalipa mshahara mwisho wa mwezi wa, yani inakuwa mtu amefanya kazi tarehe 50 ndo anapokea mshahara. We will look at you and say, no, something is happening here. So we'll say, okay, the company is not able to pay its debts. So we have that as the definition of inability to pay debts. So when someone anakuuliza a question like, okay, you're saying a company will be wound up because of the inability to pay debts, then this is what you have to explain in terms of the inability to pay debts. Now, I will take you to, I will move back, I'll stop sharing that, and then I'll move back to another document, very important, which now explains, explains the modes of winding up, which I've started at least to explain, but now I have to display them for the sake of, this is the document which I've shared with you, the notes. They contain everything that I'm talking about here. Now, in terms of modes of winding up, you will see a company may be wound up in any of the following modes: by court, which we said it is compulsory winding, or by voluntary winding up, which is, it can be members voluntary winding up, or creditors voluntary winding up, or winding up subject to supervision by the court. So you see, we've discussed the winding up by court and the reasons, which we have already mentioned them. Okay, these ones: it failed to commence business within 1 year, the number of members fall within the minimum, it is unable to pay its debts, and the definition of inability to pay debt, as you see, it has now been increased. It was only 3 points, now it is the 4th point. So now, what you see here, there are people who will be entitled to go to the High Court. We've said it is the High Court if it is not a single shareholder company. So the law says it is the company itself which may present a petition to the court of law if it wants to wind up. Or it can be any creditor of the company who will present, because anaona company sasa inaelekea magharibi, or any contributor or any shareholder. So the order that is important. It can dismiss, it can make order of winding up of a company, it can adjourn, it can do anything insofar as this petition is concerned. Now, before winding up, we say before the presentation of the petition of winding up of the company by court, the resolution, there is always have to be, oh, no, skip that one. That will have to confuse you. Now I have to go that winding up, like I said, is all about properties. It involves properties. And for the purposes of winding up, there will be an appointment that has to be made for the sake of realizing the properties or assets of the company. So the court, may appoint a liquidator or liquidators depending on the companies. So the liquidator is the person who is supposed to make sure that the winding up occurs. Because if you read the provision of the Companies Act, you will see on the appointment of liquidators, just referring if you read section 297, now it is not section section 301, you will see power of the court to appoint liquidators under the new Companies Act for purposes of conducting the proceedings in winding up a company, performing such duties in reference thereto. A court may impose, the court may appoint a liquidator or liquidators. Then it continues on the appointment style. So the court will there are styles that are explained, but importantly, I think is section 3 and 1, which is on general provisions of as to liquidator. A liquidator may be appointed by the court, and then this liquidator may also resign. It can also be removed by the court, okay, where more than one liquidator is appointed. So the court will have to state their authority, and it continues up to section 304, which is important for you to explain the powers of a liquidator. Bring or defend any action in the name of the or behalf of the company, kwa sababu ndo anakuwa anaangalia kampuni inamdai mtu, inadaiwa, anasimama hapo. To carry on the business of the company until for the beneficial winding up, to appoint an advocate, to pay any classes of creditors in full. Yeye ndo anawajibika akusanye madeni, alipe, ahakikishe kila mtu amepata kwa ile order ya payment. So you will see most of the responsibilities as stated in section 304 of the New Companies Act, they are there. They are about, I think, up to 10 responsibility. To sell the movable and immovable property, you see, to draw, accept, and make in those bills of exchange, to take out his official name, letters of administration, etc., etc. There are so many things. To appoint agents, they are there, and you've done agency law. So liquidators are empowered, and they're the ones who are to deal with the assets of the company until when an asset is brought, until when the company, everyone, the creditors and all those who claim against the company are paid if the assets permits and the members of the company. Once that is done, then their task is also done. But there are provisions also which we are not, of course, going to go deep because you're not learning to become company law lawyers on audit of liquidators' accounts. You see? So there will be provisions on their audit, their release as liquidators, because before they are released, they have to be audited, etc., etc. So we have, you see, liquidators who are supposed to be appointed, and these will then complete the task on behalf of the court for compulsory winding up. Sometimes the voluntary winding up will also be reported to the court, and liquidators will be, it depends on the wishes of the members, because in most cases, voluntary winding up, the entire process is done without court supervision, as you can see here. When the winding up is complete, the relevant documents are simply filed before the court for obtaining the order of dissolution, kwamba tupate tu death certificate. Si tulishakubaliana, kila mtu anaondoka na kile kilichokuwa cha kwake. So you see, voluntary winding up is always voluntary, and these circumstances are specific for voluntary winding up. You see, generally, we clubbed them together as 8 reasons for winding up. But there are those for specific, for compulsory, and those for voluntary. If you read these notes, you are able also to distinguish them. Voluntary will be if the period fixed for the duration of the company has expired, if an event to which the company was established has to come to an end because of the articles, if the company has resolved itself in the general meeting. You see, these are simply the reasons for voluntary winding up. And the company, because of its liability, it cannot continue. Now they say, okay, voluntary winding up will have to be done. Now, the effects of voluntary winding up is that once the company resolves that it has to voluntarily come to bring to realization of its assets, it has to cease to carry its business. Unlike when it is compulsory, where the liquidator will continue with the business until when it is completely resolved. So here you see the company in voluntary winding up, it will have to cease carrying in the business, except as may be required for beneficial just winding up. Board power will cease if they appoint a liquidator. A voluntary winding up does not necessarily operate as a discharge of company servants. So the company will have to make sure that they do not assume, you see, that we voluntarily wound up and therefore the company is insolvent, we cannot simply pay you, tunawaachisha. Voluntary winding up does not operate as a discharge of company servants, except when it takes place because the company is insolvent, kwamba imetamkwa kwamba haina kitu, na maana yake ni kwamba there will have to be now a process to prove that the company is insolvent. I'm notified that the meeting will end in the next 10 minutes. I think that is when we will also end this session. So there are different types of voluntary winding up. Like I've said, there is members. There's only one compulsory winding up, which is compulsory court winding up. But there is voluntary winding up by members, there is voluntary winding up by creditors, and there is voluntary winding up by others, as it was stated before. But mostly we focus. Simply members have to agree kwamba tulikubaliana tuanze hili kampuni. So now let us continue now tuachane nalo, au inawezekana tulikuwa tumeshaweka kwenye articles zetu, tukimaliza hii kazi, tukimaliza the specific mission, then the company has to be wound up. So we've seen the reasons for voluntary winding. Now they can be by members or they can be by creditors, because if you see in, for instance, the provision relating to creditors voluntary winding up, it is now you see that where the company is not solvent or the declaration of solvency is not made, okay? So, and delivered to the registrar in voluntary winding up, it amounts to creditors voluntary winding up. Kwa hiyo kampuni haitaki kutamka declaration of solvency of the company is not made and delivered to the registrar in the voluntary winding up, it amounts to creditors voluntary winding up. Nyie mpeleki, sasa sisi ambao tunawekeza tunaogopa, then we are allowed to go and now say, okay, let us wind up, kwa sababu creditors tutalipwa kwa zile assets zilizopo, tusije tukapoteza kabisa. So like voluntary or like compulsory winding up, you will see sometimes the court will have power. Company inaenda kufile, inaweza kasema sasa, okay, please, tumekubaliana to wind up company. Court, can you appoint a liquidator? Sasa unakuta au appoint liquidator wa kwao mwanzoni. In this situation here, what you see is that the company will appoint liquidator, but this liquidator, if he is not acting, then the court can intervene by appointing the liquidator to replace the one who is not acting. Atakuwa na delay, the court now will have to appoint the other one. And remember, it is the High Court in case of a company owned by more than one shareholder, and it is either the district or the court of resident magistrate if it is the single shareholder company. The court may also make orders in voluntary winding up to remove a liquidator and appoint any other, you see. Yeah. And the court can decide on anything that arises in the process of voluntary winding up. Sio kwa kusema kwa sababu nyinyi mmekubaliana voluntary winding up, then the court cannot intervene. No, that is not the case. That is not what you should understand. So the court can intervene both in the cases of voluntary winding up, and the court is acting on the case of compulsory winding up, which is the winding up which is supervised by the court itself, and which, if we refer to section 200 and we said it is section 283 of the Companies Act. It's supposed to be section 200 and the one providing for the reasons for voluntary, section 282, not 83. The one that is providing for the reasons for compulsory winding. Failure to commence business, postponement of the business, number of members. These all will attract compulsory winding up, which will be done by the court. So once that is done, the court will finally issue an order of dissolution, which will serve as a death certificate. So once that is done, the court will issue an order of dissolution, which will serve as a death certificate. So you see what I have looked at here. The reason, the red ones, the one that I'm highlighting, these are the reasons which are for compulsory winding, because the provisions under the Companies Act are distinguished in terms of what are the causes or reasons for voluntary winding up and what are the reasons or causes for compulsory winding up. Then we will have appointment of the liquidator, We've said about it, we've looked at about it. The liquidator will take over the controlling property. Liquidator will assess liabilities and assets, debts, claims. Ni kama kwenye natural person. Unajua mtu akifa, mali zake huko kwenye vikao vya ukoo mnamchagua msimamizi wa mirathi. Sasa here, on the winding up process, when a liquidator is appointed, it is normally equivalent to an administrator of estate, ambaye anatakiwa, sio kwamba yeye ndo amepewa mali sasa anatakiwa wagawie wale beneficiaries, kama ni watoto, ni mjane. I've used the term mjane, unajua mostly wanasema wanaume wao ndo wanatangulia kwanza, so that's why I've referred to that. So an administrator of estate will be the one who will collect all the assets. Atajua mali zake ni zipi marehemu. Haya, alikuwa na kitu gani na kitu gani, alikuwa na beneficiaries wangapi, tuwapatie kwa order ipi. So here it is the same in a company, only that a company is an artificial person. Liquidator will sell the assets to get the cash, or to get, depending on the amount. The liquidator will pay all the debts. The liquidator will distribute the remaining amount to members, and the liquidator will now terminate the company, go to court and get the order of dissolution. So the company after this, it becomes, you know, there are two important questions here. One, a deceased person, after death, a number of issues happen, and one of them is about your property and your debts. That was the example I was given. But importantly, this question, liquidator sell assets, money is not enough to pay company debts. What happens? So it will be paid according to the rank. That is why we are saying we have what we refer to as sometimes secured creditors. You pay government taxes and debts, then comes secured credits. If you paid the first 2 or 3 secured credits and government debts and the money is not enough, you will then simply have to continue to the court. That will be the business part of profit and loss. But there is a rank, there's an order, and people have to be paid as such. So this is what I wanted to share with you regarding winding up of a company. Now, one important last thing that I want to say to you, it is something regarding corporate rescue mechanism. You will see sometimes the company is unable to pay debts. Now, there are ways which even companies which are struggling are expected to survive. Sometimes we hope that, unajua hata mgonjwa akiwa anaumwa, when you have a patient, you hope for recovery. So we are hoping there are means which might help some of these companies, instead of going down because of inability to pay debts, they can, you know, they can be rescued as such. I was looking at what we refer to as the corporate rescue mechanisms or corporate rescue. Apologies, I have to put it here. I have to add a section, the type only, and I have to put these 5, 1, 2, 3, 4. Okay. So what is it? Control I. At least I have to put 20, 28. I just have to put another slide here. Need to finalize this in the last 5 minutes. And what I'm saying is, as managers, you call yourselves managers many times. We would not wish to see a company collapsing in most cases. We would want to see a company flourishing. We don't want people to die. We would want to see people living longer. Same way, these are artificial persons. And we have here many ways through which we will use to make sure that these companies survive. So I have picked the most important 10 ways.
Anaendi to all. Afu ni makusudi. Yaani watu wamechoka. Sasa mtu akiona amechoka anaendi to all. Alafu kuna issue moja hivi nilikuwa nawaza hapo. Nimetafakari juzi wakati tunatoka hapa, nilikuwa mimi alikuwa na yaani unajua maisha huko ndani sasa.
Zima mic,
zima mic, we great source wewe. Unatupa fikiri zako.
Naposha Yusuf. Kuna swali aliuliza Nuru hapo. Anasema aliuliza kwamba hivi taratibu za benki zinaruhusu kweli magari watu kuosha huko ndani? Kwamba maji hapa yametapakaa.
Sostenes, zima mic, Sostenes. Zima mic.
Unajimaliza.
Thank you. Let me finalize with the last way I'm saying we have corporate rescue mechanisms. We don't want to see these companies going down. And in most cases, we've seen this happening. We want to see them flourishing because people brought these companies. They wanted to do business. They wanted to provide services. They want to do manufacturing. They wanted to do different kind of undertakings, which are very important for humanity, existence especially. So we have major corporate rescue mechanisms, which we have to consider in most cases before we resolve to wind these companies up. As managers, you must think of measuring, combining with other companies for the sake of, you see, we are weak now, we cannot make it on our own. Instead of winding up or going down directly, if you have the brand, then consider merging with other companies. It is helping distressed companies surviving because you are consolidating resources and finances. You can allow yourself to be taken over because you can allow financial stronger companies to help you. At least if you are taken over, you've not come to an end, but your business will continue and it will even be made better by those who have the strength or the muscles to do the business. You can consider amalgamation, where at least you see you can combine with someone else. Unlike the first one where you are merging simply and to form one entity, here you will see you unite to form an entirely new company while the former companies cease to exist in amalgamation. But in merger, you can merge and do the business. Coca-Cola and Azam Cola wana merge, wanafanya business. Au unaangalia kampuni kubwa ya kutengeneza any product that you know, in a merge in a small one, and they continue to be the same in the same business. But with amalgamation, you see the former companies will cease to exist and they will form an entirely new company. You can do the reconstruction in terms of the capital. You can consider construction in terms of the debts. Now you can improve the operations in an attempt to make sure you do not wind up. There will be other many ways, including corporate reorganization, but these have also been mentioned generally. Capital reconstructions, management buyout, you see, strategic alliances or joint ventures with others. You consider any other means for the sake of making sure that you do not go down, you do not go for winding up. In a natural person, you will see it is also a tendency that people would not like to die. They will take any medicine so long as they are told these will make them survive. Do the same for companies. Don't let them go for winding up. You can go through this. I'll share with you later. And I wish that I stop here for this evening. Yeah, hello. And and allow you to ask a question or two, if any, before I log out. Please, I'll take 3 questions.
Okay, Doctor. Yeah.
Yes.
Yes. Naomba niulize Doctor, kwa sababu mpaka sasa hivi hatujafanya assignment yote. Je, kuna uwezekano ukatupa assignment 1 na assignment 2 kabisa?
I will issue one assignment. I will issue an assignment, one assignment.
Okay, kwa hiyo hauwezi kutupa na group assignment kabisa wewe mwenyewe.
I will issue an assignment. That's what I've responded. Whether it is group or individual, it will be determined on it, and I will issue it as soon as tomorrow. Nilimwambia Agnes nikumbushe tu akawa amevusha. Because now we are done with the test, which is 30 marks. I will issue an assignment of 20 marks.
Oh, okay. Thank you, Doctor. Thank you.
Yeah, that is what is prescribed. If you read the module guideline in terms of the marks, the continuous assessment will be 50%. And the 50%, if you look at it, the description is that 30 will have to come from the test and 20 will have to come from the assignments. That I will do. Thank you for reminding me, because Madam Ciara amenidoji kabisa, ameniacha sijatoa hiyo assignment. But I will issue it as soon as tomorrow. Not necessarily a group. Sijajua, naona mna login 240. I would like to know the actual number ya hata hizo test zilizoko Arusha. I was supposed to go there tonight, but I have a meeting tomorrow in Mosh. So I will have to see ziko aje, but you will have your coursework before your final exam. I was reading on assignments. It says there are questions, problems given to students, and this part will carry 20 marks for individual assignment. So mostly sisi tunafanyaga kutoa tu group kwa sababu tuna uvivu wa kusahisha. But I'll check the number, and if it is possible, I'll issue a group, an individual assignment. I have time, no problem. I can avoid AI simplified answers questions. Tatoa tu ile tutumia kidogo, utapata na kutumia kidogo at least na kupitia pitia. Any other question, please? I hope I've responded. Lazaro, twende, then Pulaki.
Yes, Doctor. I would like to get just clarification. You have said that test carries 30 marks and assignment 20 marks. Is this only for corporate law, or because all other modular subjects continuous assessment assignment is 30 marks and the test carries 20 marks?
I've been teaching this course for the past, I think, decade, and the course I simply amended. I edited this. I recently reviewed the module guideline. It has not changed. It says 50 coursework and a 50 university exam, of which 30 has to be for the continuous assessment test and 20 for assignment. And I understand why 20 for assignment, because we want people to these assignments watu wanafanya tu huko. Tukiwataka Arusha pale ndio tunaweka marks nyingi au kwenye vituo vyenu. So 30 marks for the test. It remains, and I've been doing that for years. And the 20 will be for the assignment. Thank you. Anyone else? Lazaro, umeuliza au ni Mpulaki na?
I've asked.
Thank you.
Okay, thank you so. Okay, thank you so much, Doctor, for wonderful presentation. May I have one question? But please allow me to tell my question in Swahili language so that you can capture it so well.
Please proceed. Swahili is also
okay,
part
thank
of
you.
the...
Okay, asante sana. Doctor, tumefanya winding up leo. Kuna issue kwenye financial institution. Unakuta kuna benki ambayo inakuwa BOT wana cease operation, na at the end of the day unakuta kuna depositors ambao wanakuwa na hela zao pale, lakini BOT wanakuambia kwamba depositor regardless kwamba una amount kiasi gani, lakini kama nitakuwa sijakosea, unaweza ukalipwa to maximum ya 1.5 million juu ya hela zako ambazo ulizokuwa ume deposit kwenye hiyo financial institution. Sasa with that essence kwamba regardless kwamba ni imekuwa wind up kwa procedure ambazo zinajulikana kabisa, mimi kama nina hela zaidi ya hiyo 1 million, less labda na 500,000 au 1 billion, na nafasi ya kwenda kuishtaki hiyo benki kwa sababu nimepoteza hela zangu nyingi. Ni hivyo tu Dr. Asante.
Thank you. I know most banks are companies, corporate entities, and they're transacting under our laws, companies and banking and financial institution laws. So we have BAFIAs, we have BOT, we have also the Companies Act in play. Now, there are, at certain point in time, regulations by the regulator, the BOT, which is the central bank. So we have the companies law in one hand, but we have also the central bank on the other hand. It prescribes, it even requires these companies, we refer to them as banks, to put reserve funds, and that reserve will be used in case of these incidents. Ikitokea kwamba kuna changamoto na vitu vingine. So if there is that rule which says you will have to be paid that amount, now you can sue, because no one will allow you, no one will stop you from suing the bank, but you are suing the bank. Imagine now it is the bank that is being bankrupt, in undergo what we call insolvency. Yes, you put the amount, ilikuwepo uliweka pesa nyingi, but now this amount of money, the bank has imekwenda imepata hasara, the bank has not been doing well. Even when you sue it, it means now there will be a liquidator at this point in time. Are you suing the liquidator? Because even the liquidator is trying to make sure those in the preference are paid their debt. Kwenye hiyo 1.5 inawezekana ikawa ni part of the statutory reserve fund, which you will have to get. You will have to be paid. At least umeipata hiyo. In other words, it means your investment has not paid. So even when you sue, you are suing something that will now come to an end. Something that is now, unaenda kumsuu marehemu ambaye hajaacha hata ndugu, wala hajaacha hata mali, because mali zote zikiuzwa hazitoshi watu wengine wote. So this is simply going to be just a waste of time, in my opinion, because ingekuwa ina operate inafanya vizuri, yes, you can sue and get something, but what is the meaning of suing a company that is being wound up and it is undergoing dissolution? You can ask yourself that question as well. Last question, Rukuba.
Sorry for delay. I just wanted to know, and if you have some guys who are bankers here, they can help us on that, regarding on that aspect. Because what I know, before you establish a bank, you should have to have something like a bond, according to the law, which are always being regulated by the BOT, especially in Tanzania. So what I knew,
So now,
I'm starting to be corrected. What I knew that if the bank falls insolvent, then those customers who has their outstanding in that bank has to be paid by the BOT on the same account of the bond which has been submitted before establishing that bank. So whether, I don't know whether I'm correct, or some people can correct me so that we can have alignment on that issue.
I think it's a discussion that we can continue, or I will also set part of my questions and I will expect to have some of the answers there. But normally, even when you put 100 million to a bank that is wound up by reason of inability to pay debts, you will not get the 100 million. Because what is put, mostly it is a measure to make sure that should anything go south, at least someone will get a little out of the reserve that is there. But it is something that we have to discuss from the banking law perspective. You can continue this discussion by sharing. You can text me what exactly is the what you understand, and I'll definitely have to share to everyone. But at least for now, I think winding up is winding up, and if it is winding up mostly because of issues, operational issues, inability to pay debts, failure to do business, etc., you see, it means some of these or most of these reasons are financially the financial resource liability limited related. And you cannot say, like, now if I go to sue them, I'll be in a position to, you remember the case of Solomon versus Solomon. I once discussed it with you. People opposed Solomon as a debenture, a registered debenture holder. Solomon was paid, the rest were not paid because Solomon had registered the debenture. He was a secured debenture holder. So sometimes you will see those who are only secured creditors getting paid, and even those who were simply, they were simply not secured creditors are not even getting paid because the assets are not enough, even though they have invested too much. Sometimes we invest where we don't make the necessary follow-ups. So it is, and we have to know where we are investing us. So where we're investing our monies. I'm not an expert on, I've seen the issues relating to depositors, creditors in banks, but at least I have a conception on those, the treasury bond issues. But all I know is that today we've discussed very well companies winding up and dissolution. And I think for this week, I'll say I'm satisfied that we've covered the component of corporate law. If anything pops up, and I will have to be again in touch after Dr. JJ continues from here, I will then ask Agnes for one more session before we go to the final exam. Saidi, umenyoosha mkono au umenishtua tu? Umejikuna?
Nimenyosha.
Okay, last one, then we go.
Okay, sawa. Alikuwa nataka kuuliza swali, kwa mfano ikitokea imetokea company wind up, lakini ile kampuni inatokea ile compulsory wind up ambayo ilienda mahakama ndo imeamua, then the company haina uwezo wa kupay zile obligations and the debt and all the debtors, then what will happen?
Said, it seems like you are not online with us. There will be a preferential order in terms of payment. Kampuni ikiwa wound up because of the inability to pay debts, there is a preference in payment. Government levies, government debts will be paid first. Number two, creditors. And creditors are in two classes. We'll pay first the secured creditors. When secured creditors are done, assets bado zinalipa au pesa iliyopatikana, we pay the unsecured creditors. Then we continue to members. We continue to, inakwenda hivyo, ina flow. Watakapoishia ndio hapo na order ya dissolution itatokea. Nyingine mtakuwa mmefanya mchango mwingine, na itakuwa ndio loss, the part of loss kwenye profit and loss in a company. That is what is going to happen.